Senator Gorton.
Mr. Rotenberg, since you finished, I'll start with a couple of questions for you. As I read your written testimony here, on the last page, you have 4 recommendations, which seem to me more to be cautions about the way in which we make recommendations than substantive recommendations themselves. But on the assumption that one agrees with every one of those 4 cautions, does that mean that in your view no additional legislation was needed after 9/11, either to strengthen the investigative and law enforcement powers of agencies of the United States, or changes in the 1974 privacy law to which you refer?
Well, let me say, Senator, first of all, that I felt strongly the changes were necessary prior to 9/11 to make air travel safer. And there were a lot of weaknesses in the U.S. air travel system that were fairly well known, particularly by comparison to European carriers, and that had not been addressed. I think part of the problem that you face is understanding that preventing 9/11 may be more about preventing the exploitation of security flaws than it is about dramatically expanding surveillance capabilities. Now, our panel discussion today focuses on expanding those surveillance capabilities, but I do need to say at the outset, I think even before we get to that issue, we have to focus on how we reduce the security flaws that any person who might consider harm against the United States is able to exploit. The question you ask, of course, is what changes might we make to the Privacy Act or to the federal wiretap statute after 9/11? Those changes that were made in the USA Patriot Act, I do not believe have significantly contributed to the greater safety of the United States. Now, Stuart Baker and I may actually disagree about what was happening at the FISA court in 2002 at the time that a 7-judge panel unanimously concluded that there had been mistakes in the applications for those FISA warrants. And it came as a surprise to many of us when the appellate panel reversed that determination and said that, in effect, this procedure that had been established to ensure that the lower standard used for intelligence investigations not become a backdoor way to bootstrap criminal investigations, which is now the concern of many in the civil liberties community. I don't think significant changes in those 2 laws are required, but I do believe that a lot more can be done to ensure security.
Okay, so from your view, there was not a need post 9/11 for any statutory changes in either direction, but simply a more efficient and more effective use of the statutes that were already on the books.
Yes, and I think the way this could have played out is when the government was proposing to establish new systems of surveillance, and of course many have been proposed and some put into place, as I describe in my testimony. It should have been the case that an effort was undertaken at the outset to assess how our current privacy rules would apply to these new systems of surveillance. I think that would have gone a long way to addressing some of the public concerns. In the CAP system, for example, which is the passenger profiling system, the TSA is proposing to go forward, but the required by OMB, required by federal law, privacy impact assessment for that project has not been completed. And so when civil libertarians and others raise concerns about passenger profiling, they are saying in part there are privacy obligations that that agency is obligated to fulfill that it is not yet fulfilled.
With respect to CAPS and airline security, do you have any critique or differences with a proposition for a voluntary system under which citizens who travel by air are perfectly happy to, to give up whatever is considered appropriate to get a form of identification which will allow them to avoid some of the security lines and go more directly to their gates, assuming that it's voluntary and not mandatory?
Well, Senator, if that could be made to work, I mean, it would seem a sensible solution, but I would be surprised, frankly, if those who are charged with protecting the security of the country would be satisfied by that solution. And I remember a similar debate Stuart Baker and I had almost 10 years ago over the key encryption standard, key escrow standard for encryption. And it was proposed at that time when there was strong public resistance, well, maybe we should just make it voluntary at the outset so that those vendors that want to implement this standard that enables surveillance will be able to do so. Of course, we realized, as law enforcement did, that such an approach really wouldn't fulfill the mission that was underlying the effort. And I think you would face a similar dilemma here. The people who are likely to follow the voluntary path for passenger profiling are probably those that you're least concerned about.
Ms. Miller, in a sense, the same question to you as to Mr. Rotenberg. In your view, was the statutory regime prior to 9/11 adequate and sufficient, both with respect to national security and privacy?
A couple of points, I guess, on that, Senator. First, I've said previously that that I thought that the FISA Act could have been properly clarified, whether you did it precisely as the Patriot Act did it or not. The observation I had while I was at DOD is that there was and this built up over many, many, many years through a number of administrations, there was a particular sort of ossified view of what that statute meant that occasionally got in the way of people just understanding and being on the same page and being able to go forward to the court effectively. I didn't see personally any situation where we weren't able to get what we needed under the old statute, but I recognize that there was enough lack of clarity perhaps or confusion sometimes in the minds of individuals trying to get authority under that statute that some clarification could be a benefit. The bigger picture problem that I see right now is one that hasn't really been addressed by whether the Patriot Act or any other sort of proposed legislation or oversight that I've heard being discussed, and that is that to the extent you want to do, going back to the point of this panel, to the extent you want to actually enable people to share information usefully in a proactive and hopefully preventive way, in a variety of contexts beyond what we faced on 9/11, I think, and I differ strongly with Stuart on this point, I think you have to put in mechanisms in advance to make the American public trust that technology. And it is not an undoable task. It just requires, just is perhaps too light, but it does require oversight from the executive branch, oversight from Congress, a whole set of guidelines and discussions that can be done in public for the most part, instead of behind the scenes, that will give the American public confidence that what we are doing as we use these powerful tools is designed to protect us, not to undermine our liberties. And I think that's something that can be done.
Mr. Baker, the pre-9/11 adequacy of both our security statutes and our privacy statutes, and your critique of the Patriot Act, too much, too little, what should be done?
One of the things that the Patriot Act did was try to knock down all of the most obvious legal bases for the wall between law enforcement and intelligence. And since I think that that was a major contributor to the disaster of September 11, I think that was a good idea. That meant getting rid of the restriction on sharing of wiretap information with intelligence, getting rid of the restrictions on sharing grand jury information with intelligence, and getting rid of the principal purpose rule that had emerged from practice in the FISA court.
And we needed the Patriot Act in each of those cases?
There's a kind of revisionist view that we got from the FISA Court of Review that said, gee, you really didn't need to do that. People who had properly understood the law would realize that what the FISA court had been doing for 20 years was wrong. Well, they'd been doing it for 20 years. No one had appealed it. It was, as Judy says, ossified into the practice of everyone who touched the FISA court. And that was not going to change, I suspect, without congressional intervention.
Go ahead. I interrupted you.
As far as security issues, I actually think there are some problems that we're sort of engaged in national security deficit funding on. We have yet to recognize that once you have gotten rid of the wall between law enforcement and national security, you're going to run the risk that if you try defendants for terrorism in U.S. courts, as so many people seem to now want, they're going to start making Brady motions to examine the entire take of U.S. intelligence agencies to see if they can find something that might be exculpatory. Unless you can find a way to deal with the problem of whether Brady really extends that far, you're going to run the risk that at least the lawyers for, and maybe the defendants themselves, will get to see exactly what our methods and sources are with respect to the terrorism problem. That's a big problem. I think we also, the Court of Review said, go ahead and get these FISA orders against people, and we think it's constitutional to do it even in a criminal context. But of course, if we actually try them, they're going to be making suppression motions in courts that are not going to end up reporting to the FISA Court of Review. And if we don't actually struggle with the question of how we're going to handle that, we could end up finding we have a crisis about the FISA wiretap system within 5 years.
The solutions to those problems require additional legislation?
Probably. I don't think the courts are likely to address that, although it's certainly possible to restrict Brady in particular, and perhaps even to understand the question of the FISA Court of Review clearly came to the view that it was constitutional to use FISA in this context. I am not as confident that the Ninth Circuit will come out that way.
In light of 9/11 and the particular challenges we face today, is there any appropriate review of the 1974 Privacy Act?
Actually, I don't think the 1974 Privacy Act, as it's been understood and administered, has proven to be a significant barrier, and I suspect it won't prove to be a significant barrier in the future to carrying out appropriate national security measures.
Richard?